Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. Today is February 6th. This is our bi-weekly community conference call. I'll be going over the frequently asked questions first, and then after that, the questions that are not frequently asked questions. I will not have time for new questions today. We already have about 16, 17 questions posted, and I do have a 1:30 appointment to make. So with that said, let's get started. You would have heard the disclaimers that this is not a substitute for a full consultation. I'll do the best with what I've got in front of me, but that doesn't mean this information I give you would be as reliable as something that is a detailed consultation with a lawyer. And this does not establish an attorney-client relationship. This is just community service. First frequently asked question is, so if the wife goes for H-4 visa stamping, which she did, and she got a bounce back, a 221G from the consulate that said, provide a copy of your husband's valid visa, denial letter for adjustment of status, which you have never filed. So what had happened was that there was an I-140 approval through company A with whom you stayed for more than a year after the I-140 approval. And then you moved to another company who got an H-1B amendment. I guess it's a transfer filed. This got, I see. So you moved and then you moved again with the same company, B. No, A. Okay. And then they got, okay, so you stayed with A, I-140 is approved, then you moved to El Segundo. You got an RFE with company A, they did not respond. It got denied in August 2019. My new H-1B petition with company B was approved till December 2020, even before the amendment got denied. So I'm also planning to move to company C. Can I use my previously approved I-140 petition? This is a little confusing because I don't know what the adjustment of status story is. It really has nothing to do with your case. So I'm a little confused about why they are bringing in adjustment of status, which you haven't even filed for. If you're on the phone, press *5. If you are on the phone right now, press *5. Yeah, I need a little clarification here. I'm not sure what's going on. But I can tell you generically what the law is. If an I-140 is approved and it stays approved for 180 days, and at least one of those days touches March 17th, 2017, which it did in your case, there should be no problem carrying forward the benefit of extending an H-1B beyond 6 years through any employer or any number of employers. Even if the old employer revokes the I-140, the only time you do not have this benefit is if the I-140 was based upon fraud or misrepresentation and egregious error, something like that. Otherwise, you are able to carry forward your I-140 approval benefits, such as the priority date, as well as the ability to extend your H-1B beyond 6 years. Next frequently asked question: sponsoring family-based green card while living outside the US. The general rule for anyone, US citizen or green card holder, is this. There's no law that says you cannot apply for a relative's family-based petition while you are yourself living outside the US. But when the time comes for them to go for their interview, you should be domiciled in the US, which means you're either back here or you're looking for a job, rented apartment, etc. You are in the process of moving back here. So one of the two things must happen. So can I file my family's green card for your wife from India? You can. The two dates, in your case, they are not helpful because one of those dates is only for people, the dates for filing are only for people who are in the United States. So that would not help you. You have to go with the visa bulletin dates. Okay? Whatever the final action dates for family sponsored cases are in the visa bulletin. Star 5, if you have a follow up question on this, star 5. All right. Next frequently asked question is, when is an H-1B amendment required? And there's another one following that. So, first of all, the regulation says that an H-1B amendment is required whenever there is a substantial change in the H-1B job. What does the word substantial mean? Nobody really knows the answer. We know the extremes of these. We know what it is and what it is not on the extreme sides of the two spectrums, but we don't really know in between. There are so many gray areas. So I'll give you an example. Let us say you are moving from California to New York. Do you have to do an H-1B amendment? Yes, because changing job locations is considered to be a substantial change. Things become more difficult if you are moving within 30-40 miles. Your job description remains the same, but what if the end client changes? Are you required to do an amendment? No one knows the answer, but to be on the safe side, I usually file an H-1B amendment in all cases except where a person is moving, an H-1B employee is moving within 40-50 miles of an approved location, doing the same job with the same end client and the same project. If the project changes, end client changes, vendor changes, I may have to consider filing an amendment. In most of these cases, I do file an amendment because I don't want to take a chance. Star 5, if you have a follow-up question. Star 5. Okay, let's get that question first. So this is from Pennsylvania. Go ahead, Pennsylvania.
Good afternoon, Rajiv. This is the person I posted the question.
Yes, sir. How are you?
I'm good. Thank you. How are you?
I'm well. Thank you.
Actually, my situation is I'm working for an in-house project.
Right.
So that means my end client, everybody is the same. So in this situation, my company is close to the New Jersey border.
Okay.
So the main reason is because my New Jersey is going to have some new program. So H-1B is considered to be like an in-state. So that's why I'm just planning to take my family to the New Jersey. And then just from New Jersey, I can come to my in-house project location that is in Pennsylvania. So that is my situation.
That's really moving your residence. That's not moving your job, right? So if you're just moving your residence,
right,
that has no bearing on your H-1B.
Okay, so in that situation, I don't need to do an amendment.
No, an amendment is only needed if you are changing your work location. So for example, if you were going to start working from your home, you will probably have to consider an H-1B amendment, although if it is within 30-40 miles, even if it is a different state, things get very interesting because I think personally you do not need an amendment even if the state has changed. That's the way I read the definitions. I looked into this issue a few years ago, and everything was based upon the geographic location of the employment, and that is defined so broadly that even if the state changes, as long as it is within 30 to 50 miles, I don't see it. They actually use the words normal commuting distance. I know that we have one cases where the movement was 70 miles simply because in New York, New Jersey area, it is not uncommon for people to travel 70 miles to go to work. So the words they use is normal commuting distance. So only if you are working from home, there's a problem. But if you are working from your own employer's site, all you're doing is moving your residence, no issue.
So in this situation, do I need to let my employer know that I'm changing my residence?
That's up to your company rules. Under immigration law, you only have to file a form AR11 with the government. That's all.
All right, Rajiv. Thank you. I have one more follow-up question also. The second
Right,
question.
I saw that the
So
EB1,
maybe...
the EB1 question. We have a lot of people. Actually, I just finished doing an L1A for somebody in that situation. Their company actually opened a new office in Canada because working in USA was becoming so difficult. And he went there as a manager, and we just brought him back into USA on an L1A, and we are filing his EB1C. And
Okay, and my question is like, please go ahead.
The whole family doesn't have to move, but for the EB1C, but how would they stay if you are not here? You see, if they are on dependent visas, the derivatives, they can't stay here while you are outside USA. So either they have to get independent status. For example, your daughter could get an F1 and your wife could get a tourist visa that can be extended based upon the fact that she's accompanying a minor child. But they cannot stay without you if they want to be on H4.
Because their H4 is still valid until 2022.
That doesn't matter because the USCIS says if the primary is not in USA, then the derivatives should not be in USA either.
Okay, so then I need to, in this situation, if I want to leave my family here, then I need to apply F1 for my daughter.
And B1,
right?
B2,
and then for my
B2 for your wife. Yes, sir.
Okay, B2 and F1. Yes. All right. Okay, Rajiv. Thank you very much for your help.
You're welcome. Good luck. Okay, next frequently asked question. There's two of them. Oh, somebody else just raised their hand. I'm not doing any new questions today, guys. I don't have the time. I have to meet at 12:30, make a 12:30 meeting. But as long as derivative questions, I can try. Go ahead, area code 640. Go ahead.
Hey, Rajiv, this is Khanna.
Actually, 605.
Cruz. Actually,
Go ahead. But
yes, my name is Cruz, and I think while going through the questions, probably you missed my question.
No, don't worry. Don't worry. I'll get to those. What I'm doing is I'm doing the frequently asked questions first. I see your question.
Okay.
You have said my card lost or destroyed, DHS. I think yours is DHS issued my card, but I never received it, right?
Yes, and we called them, and I also talked to the second level immigration officer, and they told me that we sent the card.
Yeah, so obviously that is your only choice, right? That the DHS issued your card, but you never received it, right?
Right.
So you are
and so is the fee waiver something that we can achieve?
I have no idea.
Choice?
I have, in my 30 years of practice, never done a fee waiver. Okay. So no idea. Sorry.
All right, sir. I appreciate you.
You're welcome. Good luck. Yeah, I'm doing the frequently asked questions first. So then we go on to the birth certificates issue. So this is a well-known problem. I think any births in India, and it'll be different for different countries. The State Department actually maintains a web page on every country. So I don't have the link in front of me, but if you Google it, you can Google state.gov space India birth certificate availability. If you do that, you will come to that page where it says, we know that there are no birth certificates available before 1970 born people. And for those who are born after 1970, the following documents should be acceptable. And so they give you a list of documents, what is called secondary evidence. And some of them are like school leaving certificate, Aadhaar card, ration cards, things like that. So that's what I would do. I would just go look for it. And I don't even know why you are doing this. Your lawyers should be helping you with this. Okay. Normally the rule is you can use secondary evidence when primary evidence is not available. So if birth certificate is not available, prove that it is not available. For example, you can take a printout of the State Department website, but your wife is probably not born before 1970, but if she is, then obviously it is quite clear that the birth certificate is not available. You can also obtain a non-availability from the municipal corporation of the city where she was born or the panchayat of the village where she was born. What that is just a piece of paper that says we have searched our records and there is no record of birth for person. Let's say the name is Rukmani. Um, there's no such birth record. So that's called a non-availability certificate. There's no particular format for it. I've seen them handwritten. I've seen them written on the letterhead. I have seen them written on even stamp paper. So yeah, there is no particular format for that. Okay. *5 if you have a follow-up question. Okay. So let's see. I actually didn't have time to go over the questions today. I did the best I could. I did a few of them, so I'll have to read them as we go along. Okay, let's return to our list now as we have them listed. So the first question, this is from BW1845479, where the issue is about cross-chargeability. So what happens if he's going through cross-chargeability based upon a wife born in a country other than India, and she has to go to her home country, but she goes without her advance parole, so she's stuck there. Now what do we do? Can he still go for his 485 interview? And you did a consultation with me last week, and I explained to you that you can definitely do a cross-chargeability even when your wife is outside USA, as long as you file an I-824 for her to show that she's following to join you. And it's not too late. Go ahead and try that, because I told you also, and I think maybe you didn't remember that, I told you that you can take the proof of filing, such as a copy of the I-824, along with the proof of delivery, such as the delivery confirmation from FedEx or UPS, whatever you use. And third, you probably will get your canceled check of the fees. You won't get the receipt so soon, but you'll be able to get your canceled check from the bank. And all of those you can carry with you to the 485 interview, and I think you'll go through just fine. You asked me a series of questions. Are you on the phone? Press *5. I guess not. You said you had 3 questions. If I go to the interview alone, will they be able to adjudicate? I think so. I think so. You did suggest split up the application. Yes, sir. Yes, sir. Is there any other option besides rescheduling? I think you might have posted this after or before you did a consultation with us, because I remember answering these questions for you. So having answered these questions, I'll skip on to the next question. Cruz's question I've already answered. These questions I've already answered. Frequently asked question. Okay. Now I'm on question number 8. I have applied for H-1B in 2018, I guess, working on L-1B. You got your approval, but yours was not a change of status case because you traveled outside the US. So what I would do is I would make sure that fact that you traveled outside USA, and you're right, if you travel outside USA while your change of status is pending, the change of status is deemed to have been abandoned. So they should not consider you to be in change of status. They should consider you to be still in L-1B. So definitely what I would do is I would call the USCIS customer service, and I will let them know what has happened and make sure somebody notes that on your file. So whether they do it or not, I don't know, but it doesn't hurt to call them. And then make notes that you've done so, on which date, which time you called the USCIS and what they told you. Okay. *5 if you have a follow-up question. *5. Okay. Let's go to question number 9. Google in turn says, grace period job changed RFE, switch jobs when H-1B transfer has pending RFE. I am on H1B, I-94 is good till May this year, laid off in November last year, got a new employer, they filed transfer in Jan. So November to December, December to January, as long as it was done within 60 days, yeah. You got an RFE which is pending, it'll take 5 to 6 weeks. I found another job which is very good. Can I ask my new employer to transfer? Yes, you can. The only problem is, if the RFE gets denied, you would be in unlawful status, unlawful presence. So you have to move expeditiously. You might have to leave USA. And if the case gets denied, or even if it is still pending, and the newly filed H-1B transfer gets approved, they will approve it without an I-94. So chances are you'll have to leave the country to get a visa stamp. Because if you had filed 2 cases within the 60-day grace period, you would be okay. But the first case is filed within 60 days, the second is not. So if the first case gets denied, you have to leave. Or if it is still pending when the second case is denied. But if when the second case is approved, your first case is also approved, you'll be fine. *5 if you have a follow-up question. *5. Okay. Question number 10. The primary applicant, husband, father, had entered on H-1B visa. His employer applied for an EB2, advanced degree. I-140 was approved. They couldn't file adjustment. Oh no, he passed away. I am so sorry to hear that. His wife and 13-year-old son also entered on H-4 visa. His wife intended to file I-765, could not complete because of his poor health. His wife would now like to take 2 steps, apply for 2014 relief. My questions are, is she eligible to perform these steps? Can they be applied in parallel? I don't remember the mechanics. I know we have done a few cases like this. I kind of sort of remember what the rules are. The rules are the I-140 is approved and at least one of the beneficiaries is living in the US when the I-140 was approved. In those cases, you can apply for the 204 for relief. Why don't you do this? Just Google uscis.gov space survivors space benefits. You should be able to come to the page about the 204. I don't recall the processing time frame, etc. Oh, somebody just raised their hand. Not sure who that is. It's a call from UK. All right, well, I'm not taking any new questions. I won't have time for new questions. But if you are the person who posted this question and you have input, let's get you on. UK, go ahead. We can hear you.
Yes, I am. I am the one posted this question.
Right.
Thank you, Mr. Khanna,
for the
opportunity.
Call me Rajiv. Please don't call me Mr. Khanna.
Sure. Thank you, Rajiv. So I have looked quite extensively in the 204L application, and I know all about how to get it done.
Right.
Maybe my specific query was the 204L relief reinstates the I-140,
right,
and and that may be beneficial to someone whose priority date is kind of coming close, and then they can reinstate the I-140 and maybe in a few months' time, apply for the I-485.
I don't recall,
but in this case,
what the work authorization rules are, but I think they're allowed to have work authorization as well. If you have any specific questions, just send an email to my colleague Suman at immigration.com, SUMAN. Because I know that we have done a bunch of these cases. She'll be able to answer any logistical questions you have.
Sure, but maybe just one policy question is for the 204L. If the I-140 is reinstated, does it also reinstate the H-4 visa status of the wife and son?
To the best of my knowledge, no. But they might be entitled to advance parole. Because parole is given for all kinds of reasons, including humanitarian reasons. So if you ask me these questions off the top of my head, I do not know. It's a very small exception to the general rules. Our office does do them.
I can understand that.
Sumanji and a couple of other lawyers are involved in those cases. But Sumanji is the person who's really the managerial person, so she can let you know. Okay.
Okay, thank you, Rajiv.
Anytime. And by the way, for 765s, usually you don't need a letter of employment. And if you are not able to figure it out, just post another question. We'll get back on the phone with you. Okay.
Sure. I mean, my goal was to file the Section 204L, reinstate the I-140 and the H4, and once H4 is reinstated, then the I-765 would, we could apply for that. But I think
know if the H4 is.
I think the key.
Yeah, I don't think the H4 is reinstated, but they might be entitled to some kind of parole. Bounce it off of Sumanji. We'll figure it out for you. Okay.
Sure.
All right. Good luck.
All right. Thank you.
Bye bye.
Thank you, Rajiv.
You're welcome. Okay, so Ram says, I'm on L1B, which is valid till April 2022. I entered, guys, I'm not going to have time for new questions. Sorry, some people are just logging in. I have a 1:30 appointment to keep, so I'll need to run right after I finish these calls. No time for new calls today. I'm on L1B visa valid till April 2022, entered US April 2017. Daughter and son are with him. Company L1 blanket renewal happened August 19. Palm filed. Okay, company appointed law firm recommended that we apply for H1. Yeah, that is true. That's a good idea. Got selected in lottery. RFE received. Got approved December 2019. I have the approval. Not yet flipped to H1. Yeah, they want you to convert to H1B this summer. Company has informed me they would explore the option of changing over to L1A. The current form, which is liable, okay. The later I flip to H1B, the more my wife can go to work. What is the risk that I run into if I flip to H1B in 2021 summer? See, I don't know the answer to that question. It's a very fact-bound question. Okay, so if your H1B is very similar to your L1A, the job description, I don't see any problem in delaying your H1B conversion as long as you want to. But if the job descriptions are drastically different, you have to assess which way you want to go. Changing to L1A will not convert you to EB1. And if your wife applies for EAD based upon the H1 I-140 combo, it can still take a long time for the approval. We just filed a lawsuit last month on H4 delay, H4 EAD. They had been sitting on that case for 18 months. It got approved within 2 weeks after we filed a lawsuit, but 2 or 3 weeks, something like that. But the problem is that if you 3-4 months delay is very normal, and I would not recommend even considering a lawsuit for a few months after that. So the problem with H4 is that it's going to take time for the EAD to come. L2 EADs are a lot quicker. And as far as the L1A change from L1B is concerned, it happens all the time. That's nothing new. If you're on the phone, press *5 if you have a follow-up question. Anyone has a follow-up question? Okay. Let's take this call from, I guess, Texas? No, California. Okay. Yeah, California, go ahead, please.
Yeah, hi, Rajiv. Thank you. I was the person who posted this question. So, thank you for answering that. The flip from L1B to H1B, as far as the job description doesn't change, can be done as late as possible.
Yeah, no, hang on. But you said, no, hang on. The comparison should be between the L1A job and the H1B. Because my concern is, if you are given a managerial job, oh my God, they have some construction going. Hang on, let me put my headphones on. Just 1 second. Just 1 moment. Can you hear me? Okay, good. So the comparison should be made between your L1A and H1B. Yeah, I can hear you. Yeah, hello. Yeah, I can hear you. Hello. Okay, for some reason you couldn't hear me, so I'm just gonna take this off. We'll deal with the damn drilling.
Hello?
Yeah, I can hear you. Hello.
Oh, hi, Rajiv.
Okay, so
So
the comparison
yeah,
should be
the
between
change to L1A is not promised by the company.
Okay.
So currently I'm on L1B.
Okay.
I have an approved H1B petition in
Yeah,
hand.
no, all that I know,
So,
all that I know. The question is, can you delay it? And the answer is sure. I have a case in which we have, we just last month only, somebody entered USA after 1 year of H1B approval. The problem was that his project was delayed and he was working on the project from India. So when he came, he wasn't asked any questions. As long as the job is available, you can delay the H1B if you like. Okay.
Okay. All right. So there won't be any extra scrutiny if I'm flipping to H1B a year or
scrutiny is not the problem. Coming out a winner at the end of the scrutiny is the problem. They can look at anything they want. The question is, are you in a legally good position? And the answer is yes. Okay. But do discuss with your lawyers. I don't know all the facts of your case. Based upon what you have told me, that would be my answer. Okay?
Okay. All right. Yeah. Thank you very much.
Good luck, sir. Sorry, guys, they have some kind of construction going on in the suite above. It's just crazy amount of noise. I have dealt with the birth certificate question before, question number 12. I had a birth certificate question as a frequently asked question. So what the alternatives, etc. are, go ahead and review that answer, and that should answer your question as well. GS says my current employer is planning to file my H1B extension in premium. Another future employer is going to file the I-140 also. Is there an impact because I have an H1B with one employer, I-140 with another? No. As long as you have the good faith intention, honest intention to join the I-140 employer, either before or after you get your green card, having them both go on is no problem. Star 5 if you have a follow-up question on this. Press star 5, please. Okay. Oh, these guys are so annoying. Then the public charge rule. The Atlanta resident says there was some emergency Medicaid taken, etc. Now, I'm still reading the public charge rule. I had started reading it and then I stopped. But so far what I have read, it says that they are only going to apply it to things that happen after 24th February. So they should not be affecting you based upon the past receipt of any kind of aid. Okay. Star 5 if you have a follow-up question. Okay. Then Mohan says, I'm a student in third year of OPT extension. Last chance for H1B this year. Got suddenly laid off on Jan 29th. I can try to convince my company to at least file H1B initial registration. Can I transfer my H1B to another employer? Yes, of course, as soon as it is approved. I don't see any problem with that. How late should my last date with the current company be for this option to work? So I would like it to be, let's say, because we'll be able to, your lawyers will be able to submit your H1B within 90 days after April 1st. So giving them a month's time, it would be great if you can hang on to your job till May 1st and make sure that your lawyers file your H-1B on or before May 1st. Okay. There is a 60-day grace period also. When does your current OPT expire? It's December 2022. Yeah. So yeah, extend it to May 2022 if you can. June would be even better. But make sure whatever date you choose, it must be after April 1st, and it must be the date by which your H1 can be filed. Star 5 if you have a follow-up question. Star 5. Okay. GAT33 says, I'm an Indian national. I got accepted to a top 20 full-time MBA program. Congratulations. I've been on L1B since 2015. L1B will be expiring in July. Classes start in July. My company decided to apply for my green card in the EB3 category. I-140 has already been accepted. So normally I see that people are getting their student visas or student statuses even with the green card application having been filed. At least traditionally USCIS has been quite understanding. I don't know about the Trump administration's approach, but under President Obama, I know dozens of people in your kind of situation. One or two of them actually had a 485 pending, which they withdrew. So theoretically, at least, this is possible. As a practical matter, who knows? I don't know about withdrawal being helpful, because remember, the question on the form that you use, I-539, says, has anybody ever applied for immigrant visa for you? So even if you withdraw it, you have to answer yes. I'm applying for Canadian PR in express category. Would that change anything? Look, I don't know what the Canadian laws are, but on the US side, having applied for Canadian immigration should have no impact. Okay. So it might have some positive impact that you have a third country to go to. You could even apply for a student visa from Canada, which might make things a little easier for you. But I can't predict how the student visa or student status issuance would go. Star 5 if you have a follow-up question. Star 5. Okay. Zoomer123 says, I need a small help. Sister's H1B for 2020. She's on H4. She's doing masters. Is she eligible to apply for H1B this year? She has 2 more semesters to continue. Well, I don't know what her bachelor's degree is. She has to have a degree. Oh, somebody just raised their hand from California. Okay. California, go ahead, please.
Yeah, Rajiv, the thing is, this is regarding the question I asked, and it's actually tagged as #3. I'm sorry to interrupt suddenly. I joined little late. Will you be speaking on this question a little later?
Which question number is that, sir?
It's third one.
Oh, that has been done. It's been recorded. You can listen to the answer. I have to finish up my other calls. Okay.
Sure, thank you.
Good luck. Okay. So I have incomplete information here, but if she has a bachelor's degree in a specific subject and or 3 years experience in the field, she can qualify. But what the USCIS said was, when you do the registration, even if you don't have a degree, it's okay as long as you have the degree by the time you apply for your H1. Okay. No, she won't make it because August 2020 is April to May, May to June, July. Yeah, she won't qualify based upon the master's degree because it won't be done by that time. Yep. So I've answered the question. Do you have any follow-up question on this? Press *5. Okay. So let's do the last question. Then I've got to run, guys. This is from Romer. Is it okay for anyone to apply for H-1B when sibling sponsorship has been filed? Oh yeah, because H-1B, L1, H-4, L2, these kind of visas are not affected by green card. And you can have green cards going in multiple categories also. Yeah, I don't see any problem applying for an H-1B with the green card going on. So that's the least of your problems. And you can also file a green card through multiple categories. If anyone has a follow-up question, press *5. Okay, very good. I think we are done for today. So I'll see you again in 2 weeks, folks. Sorry I had to run. I've got a call scheduled in 10 minutes that I've got to go to. I will talk to you again. It's always a pleasure and delight to speak with all of you. Thank you for being here. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.